Hi, this is Bezel Bay, and today you'll be enjoying WTDTA radio, where we'll be exploring the world of accounting, current expected credit loss provisions, estate planning, and tax planning, just to name a few. Don't forget, in the evening session, we'll be definitely going into civics and syntactical trust. So remember, if you listen long enough, you will definitely learn something. Peace and love, family. Peace and love.
Okay, we are now recording. It is May 3rd, 2016. This is the Trust webinar. This will be a series of webinars that we'll be going through as for dealing with and understanding trust management. This webinar will not be dealing with the formation of trust. We'll be dealing with the management and exactly how to operate a trust. Okay, what it is that you actually have. Actually, in my opinion, the formation of a trust can be taught in 1 hour, because all a trust is just a document. There are some additional things you do need to do in setting up the trust, that can cover some time. But I wanted to, before, you even get into all of that, I wanted to go over some things with each and every one of you and understanding how to study and analyze the subject of trust. Okay. As I said, the webinars that I'm doing right now, if you're looking for paint by numbers, I'm not doing paint by numbers anymore. Okay. I'm teaching people how to think on their own, how to analyze information, how to create their own documents, how to create their own processes and things of that nature. So, this is, if you want to call it an advanced class, you can, but I don't think it's advanced. I think it'll be something that'll be very enjoyable for you. Because basically I'm essentially showing you how I get down, my study habits, how I investigate things, how I arrive at conclusions, how I find information, and how I do things. Y'all listen to my show, you want to see how I do things. And hopefully what you will glean from all of this is a new understanding of trust, as well as, a loss of any fear about dealing with trust. A lot of people, they have some anxiety about going to the law library. They think that, going into the law library, those law books are very complex. They're too transcendent, just things of that nature. And I'm here to tell you that that's not true at all. You can learn how to navigate a law library in a day or two. It doesn't take long. And after a couple of trips, it will become actually an enjoyable thing, because you'll be able to find information that you're looking for. And you'll discover that there is a lot of information out there. A lot of the questions that y'all have on, filing court cases and things like that. I mean, they got forms and everything for everything in the law library. It's just unbelievable. Case in point, if I was the kind of person that really was just money hungry, making trips to the law library, I could just be endlessly doing webinars showing y'all different ways to file documents and do all kind of things. And all I would really be doing is going to the law library and copying stuff out of forms and pleadings books and, things of that nature. It really could get, into that. But, I'm not into that kind of stuff. I'm more into wanting you all to understand, how to go and find information for yourself, how to form things, and how you study for things. Okay, before we get into things, I want to first of all start with how I study with things. The first place I always go and study about trust is the law library. I go to an American jurisprudence. I go to either a legal encyclopedia like American Jurisprudence or Corpus Juris Secundii. And the reason for that is because I studied through case law. How I was mentored is either you're going to have someone who can mentor you in trust, or you're going to have to read a lot of case law if you don't have a mentor. And most of you, well, you got me, but, just on your own, you can find out a lot of stuff. I found out stuff that even my mentors didn't know just by reading case law, things that were never told to me. I'm like, did you know this right here? That you could do this? It's really interesting. Like the doctrine of merger, nobody told me about that. I was under the impression that you couldn't be a trustee and a beneficiary at the same time, and come to find out you could. It's just that you cannot be the sole beneficiary. And I discovered that actually through reading case law. But today, first of all, I want to bring your attention to this. On my website, which is a high frequency blog talk, high frequency radio network.com, you're going to notice that I put two American jurisprudence. This is an American jurisprudence on trust. This is an American jurisprudence on business trust. All right. Now, the reason that you see that these are in two different books is because there is some sort of disagreement in the legal community as to whether or not a business trust can really be considered an actual trust. Okay, but it is a trust. It's a trust, but it has a little bit of a couple of differences than the average trust. Today we're going to be discussing business trust because these are the trusts that I feel that you should be more interested in, because all of you are attempting to go private, and you have to learn how to basically operate your life through a trust. Your life is essentially a business. And so you have to, learn how to operate your business through trust. Does that make sense to everyone? I hope I'm not losing anyone here.
Yes.
Okay.
That makes sense.
Absolutely, yes.
All
And
right,
it's clear thing.
Okay, great. So let's start. We're going to open up. This is an American jurisprudence. This is an electronic version of it. Okay. And the reason I like to start with business trust American jurisprudence, is that it is just replete with information, more information that you could probably get in any book. If you know what you're looking for, if you know how to study. A lot of people, what they're doing is they're looking for someone to give them some sort of document to read, or maybe buy some sort of book. And I am going to be providing you a copy of Successful Management. It's a $750 book, but I'm going to give it to you in sections. Because I'm going to force everybody to come to all of the trust webinars. So you'll get it in like section 1, section 2, section 3. I won't give it all in just one webinar. That way you don't have to buy the entire book, but you will have to attend all of the webinars if you want the entire book. Does that make sense to everybody? Yeah. So it is a great book. It is a very good book. It was written by an attorney. You will not find it on the internet. It's not a published book or anything like this. A lot of the real information that you're going to find as it relates to private trust is not published information. It's basically information that's been gleaned from individuals who have a lot of experience over the years, who have put that experience down in books and so forth, and passed it on privately to individual. However, you can find a lot of information in the law library. As a matter of fact, American Jurisprudence has a forms and pleadings book where they have their declaration for trust in business trust in the book, and I have some of those as well. Right now, we're going to start out with the topic of business trust. Now, business trust goes by many different names. Another name for it is called a common law trust, or a Massachusetts trust, or an unincorporated business organization. I want you to pay attention to the word unincorporated. Unincorporated. It is not a corporation. So let's read this first. It says, this article considers the business or Massachusetts trust an organization created voluntarily by a trust instrument whereby trustees manage the trust estate for the benefit of holders of transferable certificates representing their proportionate interests and rights in the proceeds and corpus of a trust estate. Now, let me stop for a second. That is an excellent definition. Can anybody break down what was just said right here? Okay, when it says a voluntary by a trust instrument, what trust instrument are they talking about?
Birth certificate.
No. Talking about
Certificates.
no. It's talking about the declaration.
Indenture.
Isn't it the declaration
Yes.
of trust? Isn't it your initial trust document?
Yes, we are. We're talking about the declaration of trust and the indenture agreement. The declaration of trust and indenture are not the same thing. However, both can be present in the same document. Okay? Now, so we're talking about the trust instrument. When you see this, this is talking about that. And where it says, whereby trustees manage the trust estate for the benefit of holders of transferable certificates. What does this right here mean? Holders of transferable certificates. What is that talking about?
The beneficiaries?
Yes, it is talking about the beneficiaries, but what are transferable certificates?
They're certificates that show the beneficial interest in the trust.
They are. I'll tell you what a transferable certificate is. It is a trust certificate. Okay, a birth certificate could be considered a transferable certificate, but it is a transferable certificate, meaning that you can't give it to someone else. It's transferable. Well, let me give you an example. If I have a trust certificate that says I'm supposed to get $1,000 a month from the trust, I can transfer that to someone else, and they can be receiving the $1,000 a month. Does that make sense?
Yes.
Okay.
Yeah.
This is exactly the same as a stock certificate. Okay. Like in a corporation, now you're going to find out that a corporation and a trust, a business trust, are very similar. However, there are some glaring differences between the two, and they have to be present. These differences are going to be necessary for you to understand, because when you are operating a trust, one of the things that you're going to have to watch out for is the IRS. What the IRS is always watching for is whether or not you are operating your trust as a trust, and if not, how you're operating it, and whether or not they can construe it as a partnership or an association. The danger in that is that if they construe your trust as a partnership or an association, you'll have what is called a deficiency to look into. And what do I mean by deficiency? What I mean is this. If you've been operating your trust for 2 or 3 years, and you've been telling everybody you have a trust, you got a 9(8) number, you got your indenture agreement and all of that. However, something happens and some questions arise, and the IRS start to draw their attention towards your business. And looking into your business, they find that you have not been operating correctly. You haven't been keeping trust minutes. The beneficiaries have been exercising control over the corpus or the trustees. Maybe the trustor, he's been exercising control over the trustees or the trust corpus, anything. And if they find out that that's been happening, what they're going to say is that you have a sham trust, and for the last 3 years you've not been operating a trust. You've been operating some sort of partnership or an association, and therefore you owe taxes for the last 3 years, because this entity that you are operating is tax exempt. That's why you have a 9(8) number. It's private. It's tax exempt. It doesn't have any reporting requirements if it is operated in a specific way. Just having a private trust doesn't necessarily mean there won't be any reporting requirements. That's going to be heavily predicated on the business that you engage in. Now it goes on. It says matters treated include. Oh, let me blow this up some so y'all can. Is that big enough right there? Everybody see that?
Yes.
Okay. So right here, this is where we're at right here. Okay. Matters treated include the creation, organization, and duration of a business trust, the nature, attributes, and liability of the trust estate. Okay, when we're talking about liability of the trust estate, naturally, we are talking about some sort of tax liability. The shareholders. Shareholders is another name for trust certificate holders. Okay? As I said, a business trust is very similar to a corporation. All right, but it is superior to a corporation. It's superior to it. Members are sesque trusted and their rights, shares, and liabilities. Trustees, officers, and agents of such a trust, and their powers, rights, and liabilities. Taxation and governmental regulation of business trusts. Determination, dissolution, reorganization, and merger of such trusts, and practice and procedures in cases involving business trusts. Insofar as peculiarly, I couldn't pronounce that word. Oh man, I'm gonna have to mute y'all. We're recording, so don't open up your mic unless you have a question. Okay. The termination, dissolution, reorganization, and merger of such trusts and practice and procedure in cases involving business trusts insofar as peculiarly relevant or distinctively applied to such trusts. Now, when we go on, I'm going to show you why I always start with American jurisprudence. All right. This right here, I want you to write this down, and I want you, if it's possible, commit that to memory, because that is the definition of a business trust. All right. You're going to see that written in different ways in different books, but essentially that's the definition of a business trust right there. All right. So when we go into it, you start this, that's the table of contents, which is a lot, as you can see. We get into business trust. Now, I'm going to show you why has anybody ever used American jurisprudence before?
I have.
Do you understand what you were looking at when you were using it?
Yeah, it's hard to explain. Okay, so it's basically an explanation of what they consider the statutes to be.
No.
Like opinions?
No, it's common law. And let me show you what I'm talking about.
Jurisprudence is common law, really? You mean AMJUR, right? When you say juris?
Yeah, what common law meaning that we're talking about case law. In the sense, I'm using common law in the sense of case law. Okay. I'll explain it. Let me explain it.
Okay. All right.
Definitions and nature, validity. Okay. Definitions and terminology. Now, what I want you to pay attention to is these numbers. These numbers are what are important when you're reading an American jurisprudence. The reason why these numbers are important is because this entire paragraph is nothing but case law. These are sentences that are pulled out of different cases. All right. And what they have done is they've organized all the sentences from different cases in such a way that it has created a paragraph. So when you're reading an American jurisprudence, what you are reading is what?
Case law.
Case law. Okay? Did that fly over anyone's head? Did anybody not understand what I just said? Because I'm about to demonstrate. I'll explain it. Don't answer that. I'm going to explain.
That hit home. That hit home. I did
Yeah, I got it too. I understood that too.
Okay. Let me show you what I'm talking about. Okay. One of the distinctive devices by means of which individuals may combine their resources to operate a business for profit is the so-called business trust. Now, why do they call it so-called? As once again, because you have a book called Restatement on Trust, which is the authority on trust, and they did not want to include business trust in that, even though there is some argument to the contrary. But it's called, now notice this is a business for profit. It's the so-called business trust or Massachusetts trust. Now, the reason why they call it a Massachusetts trust, because Massachusetts is the first state that started utilizing these type of trusts. I don't know if y'all remember the Rockefellers and a lot of other people like that. They were a lot of individuals, a lot of wealthy individuals in the late 1800s and early 1900s organized these organizations in Massachusetts to avoid taxes and a lot of other stuff. And this gave birth to the 1909 Corporation Tax Act and a lot of other amendments to that particular act that happened over time all the way up into this present day. And also, rooted in that is your straw man. The Corporation Tax Act of 1909 is the origin of how the straw man kind of came into existence. You know, when you do your studies, I mean, it might not be how it came into existence, but it's definitely connected to your straw man. Okay, so let's go. It says, one of the distinctive devices by means of which individuals may combine their resources to operate a business for profit is the so-called business trust or Massachusetts trust, which may be comprehensively defined as an unincorporated business organization. Remember, I told you that. Created by an instrument by which property is to be held and managed by trustees for the benefit and profit of such persons as may be or may become the holders of transferable certificates evidencing the beneficial interest in the trust estate. Once again, there's the definition of an unincorporated business organization, this whole entire first sentence. Now, we just talked about transferable certificates and so forth, and notice that it's created by an instrument. Now, the thing about a business trust, what makes it private, is you are not taking it down to the Secretary of State and incorporating. You don't need any incorporation papers. You don't need to go to Staples or do any of that, okay? That is what keeps it private, okay? Keeps it in private hands. When you incorporate something, you are giving it over to the state. What you're saying when you incorporate is you're saying that you want the state to regulate it. Once again, this is where the straw man it comes in and has so many problems, because it is what is called an ens legis, which means creature of the state. The state has created it, and therefore the state has the authority to regulate its activities. Okay, does everybody understand that?
Yes.
Okay, so let's keep going. It says such an organization has also been frequently termed a common law trust. Remember at the beginning I said it's called a common law trust. Write this down because we're going to put it in our test. A Massachusetts trust, an unincorporated business organization, or a business trust. All right, those are the names that you will see this thing called. Those four things. They'll say a business trust, a Massachusetts trust, an unincorporated business organization, or a common law trust. These all mean the exact same thing when you see that, okay? But it goes on, it says, but this phrase is not descriptive of any of the peculiar characteristics of such organizations. Now it goes on, it says, business trusts are excluded from the coverage of the restatement of the law on trust. Remember, if you can get a copy of this book, you can. This is considered the authority on trust law, is restatement on the law of trust. I want you to write that down. You need to be very familiar with that book if you are going to do any type of claiming to have any knowledge of trust whatsoever. All right? So business trusts are excluded from the coverage of the restatement of the law on trust, wherein it is pointed out that the business trust is a special kind of business association and can best be dealt with in connection with other business associations. Under the Uniform Commercial Code, the term organization, unless the context otherwise requires, is defined to include a business trust. So notice what they call it, an unincorporated business organization. So under the UCC, organization also includes a business trust. All right, now, this is what I want to bring your attention to. Now, when we look at these numbers, you see number 2, this was the definition of trust. Now, where did that come from? Down here, you're going to go down here and you're going to read this. And the case that everybody should be familiar with is a case called Heck versus Malley. There are some case law that if you are going to say that you are a trust expert, you should know. You should have read it. You should know what it is saying. And that is what we're going to do today. We're going to go through case law first, so you can get an understanding of what goes on in court, okay? Because court is going to be your best teacher. So right here, what is happening is these numbers are directing you down here where you can see what is called a case citation. This case citation is where you're going to get your education from, all right? So it says so-called because the type of organization has reached its fullest and most extensive use in that state. Now, right here where it says it's called a Massachusetts Trust. So if we want to find out...
Hello, everyone. Welcome to our Tuesday Q&A with Lynette Zhang, our Chief Market Analyst, and myself, Eric Griffin. I'm the President of ITM Trading. And for those of you who don't know or are just tuning in for the first time, we do this live Q&A.
If you're also a trustor, would be setting up a slick indenture agreement that sets you up for maximum success.
That's where the power is. The power is in the indenture agreement that you set up. And we're going to go through an indenture agreement in this series. We're going to go completely through an entire indenture agreement at the end of everything once we learn all of this stuff. I want y'all to get all of this in your mind first. And once you get all of this in your mind, once you begin to read the indenture agreement, it's going to become clear why we are going through all of this. All right? So let's understand something. Okay, an irrevocable trust, like a Massachusetts business trust or an unincorporated business organization, these are irrevocable entities. Okay, the trustee has all the power. That power is derived from a document, just like your government officials. Your government officials get other power from the Constitution, which is a trust indenture. It's a trust. That's why they're called trustees. So everything that the government officials have to do, they cannot violate the Constitution.
Hi, this is Bezel Bay, and today you'll be enjoying WTDTA radio, where we'll be exploring the world of accounting, current expected credit loss provisions, estate planning, and tax planning, just to name a few. Don't forget, in the evening session, we'll be definitely going into civics and syntactical trust. So remember, if you listen long enough, you will definitely learn something. Peace and love, family. Peace and love.
They have to do everything the Constitution tells them to. Now, can you understand how this same principle is what you're doing right here with an unincorporated business organization? They form counties and cities based off of this. So, let me recap. In an unincorporated business organization, a trustor cannot exercise any authority over the trustees, neither can the beneficiaries. If either of those entities start to tell them what to do, what will happen is your trust will be construed as an association or a partnership. And there is a different tax bracket associated with that. And if that trust has been operating for a number of years, what the IRS is going to say is there is a deficiency. They're going to go back through all the years, and then what they're going to do is they're going to say, well, this was not a trust that was tax exempt. This is actually was operating as a partnership or an association, and there's a 30% a tax liability associated with that, plus penalty, interest, and fees. Does that make sense to everyone?
Yes.
So do you understand right now why it is incumbent on each and every one of you to learn how to manage a trust? Because forming a trust doesn't mean anything. It's called form versus substance. Courts do not look to the form. They look to the substance. They will read your indenture, and then they're going to start to look at your activities, which amount to the substance. Okay, actions speak louder than words. Okay, we know you have a trust agreement, but did you do everything your trust agreement said you were supposed to do, or did you engage in some other activity that can be construed that you were actually trying to do something else? You formed a trust and made it look like a trust, but in actuality, you were really doing something else. And this is the case with most of you out there. Y'all are going out getting 9-8 numbers and forming trust, and you don't know the first thing about trust. You don't have no trustees. You didn't do an exchange. You don't have no beneficiaries. You don't have a trust protector. You don't have any trust managers. You don't have bank accounts. You don't have trust minutes. You don't have any of those things, but you're all running around talking about just because you got a 9-8 number, you're operating in trust. This is the most ludicrous, ridiculous thing ever, and it is irresponsible. And I don't care who's out there talking about me. You go back and I tell them, well, I ain't gonna say that on a recording. I'll get real fly at the mouth. You know what I'm saying?
Don't worry, Yusuf. I already did.
Okay. So right here it says, if in fact a trust has been created, the shareholders are not personally liable on the obligations incurred by the trustees or the managing agents appointed by the trustees. Now, this is where authentication of the birth certificate does come into play. Okay, you as a beneficial owner of the certificate, you don't have any liability. Okay, you're a beneficiary. You cannot exercise any control over anything. However, you are what? You're a beneficiary, and as a beneficiary of the trust, you cannot be held what?
Liable.
Liable.
Personally liable.
So what is this word shareholder? What's another name for shareholder in trust?
Beneficiary.
Beneficiary. Trust capital unit holder. units of beneficial interest. These all mean the same thing. Write that down. They'll use the word shareholder, but in some documents they will use trust capital units. Sometimes they will use trust certificate. Okay? These are the words, but they're shareholders. But are we talking about a corporation? No, we're not talking about a corporation. We're talking about a trust. But a business trust and a corporation are very similar. What do you think one of the main difference between a trust and a corporation is? Who can tell me?
Corporation have a board.
So does trust. Trust has a board of trustees.
Right.
The way that it's taxed.
The trust is private, and the corporation is basically you're being controlled by.
There are private corporations.
Honestly, I was going to ask you that.
Even though they're different, a private corporation is different than a private trust in the sense that a private corporation hasn't gone public, in that there aren't any shareholders. The people of the corporation still maintain control of the corporation. All right. It's a little different, but I'll tell you what the biggest difference in a trust and a corporation is, that a corporation do not die and trusts do. Trusts die. Corporations don't. Okay. A trust has a termination date. A corporation does not. Write that down. Trusts have termination dates. Corporations do not. That's one of the main differences.
You said, what's the longevity of a trust, like the maximum time that it can be alive?
You can make it as long as you want. You have some trusts that go 99 years. And then, but what it is not the maximum time you're concerned with, it's the minimal amount of time. And the minimal amount of time that you want to create a trust for is about 7 years.
And then once that term has ended, do you just create another indenture, or?
No, you can make a provision in your trust indenture for the trustees. Okay. You can give the power to the trustees to renew the trust for another 99 years, or however long you want to do it. So in reality, it can go just as long as a corporation. It's just that you have to put in the indenture agreement, because the trust is a creature of contract. All right. And as a creature of contract, you can contract unlimited. Contract makes the law. So if you want to put in your contract that at the end of, say, 7 years, you can give the trustees the power to renew the entire indenture agreement for another 7 years. But that power is something that's going to be given to the trustees, and it is something that they will exercise in their discretion if you give them that discretion. You can also say something like, well, the beneficiaries will give permission to the trustees to go ahead and do it for another 7 years or whatever. There are things that you can put inside of it. I'm not really sure on that right there, because that might be giving the beneficiaries too much power over the trust. But the thing is that you get my point, okay? And we're going to.
Well, how does that work with the trust that they make as far as the birth certificate? And who continues that one?
It is considered a charitable trust. Now, I'm glad you asked that question. Guess what? The charitable trusts have termination dates. No.
Oh, that was a question. No, okay.
Oops. Look at it, terminating an irrevocable trust. Let me see, terminated charitable. See, can you undo a charitable trust, early termination of trust, charitable trust termination? They got ways of doing it, of course, but complete terminations of charitable remainder trusts are appealing for two primary reasons. The donors no longer, you can go and explore it for yourself, but a charitable trust is unique in its sense. Public charitable trusts do not terminate. They can be terminated, but they can go on forever if there's no outside action taken against them. Okay. All right.
Is that what they use the death certificate for?
I'm sorry. Yeah, exactly.
Is that what they use the death certificate for?
Exactly. Good. Very good perception. Very good perception. What you're going to see is that they are operating in trust. Everything that they do is trust. That's why you got to learn trust law. If you really want to understand redemption and the UCC and everything that's been going on, you got to understand trust law, because everything they're doing is operating in trust. It's based off contract and trust law. It's really trust law, commercial law, tax law, and accounting. Those are the four things that you got to learn. You got to learn trust law, commercial law, tax law, and accounting. Trust law, commercial law, tax law, and accounting. All four of those things intertwine with each other. Now, look at this. This is something very important. The law is clear that in the absence of an express or implied agreement with the creditor to the contrary, the trustees are personally liable on all contracts with third persons. Now, this is what we're going to be talking about also. When you form your trust indenture, okay, let's say like your trust. Let's say you operate a trust, you got a gym with a whole bunch of equipment in there. And you have to contract out for outside services. Okay, and so your trust is going to form a contract with another corporation. And every contract that you form with an outside entity, you have to put a clause in the contract that trustees are not personally liable on all contracts, and that they will have to look to the trust itself. Okay, you're going to see that in the trust indenture that we're going to be doing. Now, this also should give you a clue as to when you're drafting any type of documents in the public with trustees, when you're trying to express a trust to them, what type of language did you put in your correspondence with them? Then I hope that didn't fly over anyone's head.
It's like without recourse.
Without recourse is similar. That's what UCC 3-20, that's why they said that's the remedy. 3-308 and 2-207. Exactly. You don't have any recourse against me. Exactly. You're reserving all rights. But that could be expressed in a different way. That's exactly what this is. This is a reservation of rights clause. All right. Look, okay, here's another one. Let's look at this. Stating that it is generally held that the power to elect trustees and fill any vacancies in the board gives the certificate holders such ultimate control over the trustees that the organization will be treated as a partnership and not a true trust. Now, this is very important for you to understand. All right. What can you not put in your trust indenture? You cannot put in your trust indenture where you're going to give the power to the beneficiaries to fill vacancies in the board of trustees. All right? You cannot give any power to them. So your trust indenture can't say, well, if the trustee dies, or if a trustee quits or something like that, the beneficiaries will decide on who's going to be the replacement trustee. If you put that in your trust indenture and the judge reads it, he's going to say you don't have a true trust. You have a what? Partnership.
That's close to what you were saying about the renewal as well.
Who would have that power, the trustor or the grantor or?
The trustee. Okay, once again, when you draft, I'm going to show you that. Why do you think our indenture agreement is 42 pages long? Okay? It's 42 pages long. The one you get from the law library, it's probably going to be about 8 pages long max. The one that they're giving, who on this call says they got a trust? Somebody at the beginning of the call just said they had a trust. I want to ask you a question. How many pages is your trust in your trust agreement?
I have some that's not active yet.
Elizabeth James says it's over 20.
20 pages. That may be good, depending what's on it. Who else? Somebody said they had one. What?
It's not. I have like a holding trust. It's only like 8 to 10 pages. Then I have a management trust that's about 20 to 25 pages.
20 or 25 pages. That may be good. When we go over this trust indenture agreement, you're going to see whether or not your trust has any deficiencies or not. Okay. All right. Let's stop right here. Okay. Now let me go back to this case. But see now Now how did we get to this case? We got to this case because we started American jurisprudence. Okay. From American jurisprudence, what you're going to do is when you start studying about trust, every time you read one of these things, if you see a sentence in here that is very interesting, if you want to expound or expand on your knowledge, that's why they put these case citations down here, because they want you to go and read the case law. Okay, this is what you have to do. If all roads lead to court, then you need to read case law, because you should have some sort of notion and anticipating on what the courts will do if you have a same situation that comes up. It also helps you because what we're going to find out in a little bit, it will teach you how to make money also. What do I mean by that? You're going to find out very shortly. Okay? Let's get back to this case real quick. What time is 9:20? We're going to keep going. All right. I'm going to read through this as quickly as I can. It says, this is a Massachusetts or business trust, and both parties recognize the case of Goldwater versus Altman as the leading California case on the subject. The case holds that trustees of Massachusetts Trust are personally liable on all contracts with third persons in the absence of an express or implied agreement with the creditor to the contrary. So in other words, this is why you read case law. This right here is teaching you that you have to put in your trust indenture or any contract. Now, when I give you this successful management book, it has contracts in the back. And these contracts are all going to contain a clause in it that says that the trustees are not to be held personally liable on any contracts that the trust engages in. If you do not put that in your indenture agreement, every time your trust engages in a contract with an outside entity, is that trust going to be liable, or are the trustees going to be liable?
The trustees.
The trustees are going to be liable. Now, this right here, I know right now, you're right now, this is the first class, but this is very important because you're going to see this in a lot as you begin studying trust. This is why they have a whole case surrounding this. All right, you got to know how to draft a contract. You have to know what your trust indenture needs to contain in it and what also you need to leave out. There are things that you can put in your trust indenture agreement that will hurt your trust if it ever goes to court. You understand what I'm saying? Just as I said, giving the power of beneficiaries to replace trustees. That will your trust. Does anybody not understand what I just said?
Yes.
Okay, I'm going to pause right here. Okay?
Say that again, please, User.
I'm sorry?
Say that again. You kind of broke up.
What I was saying. Okay, what did you didn't hear? You didn't hear what I just said as far as the indenture. I was saying that you have to know what to put in an indenture agreement, and you also have to know what to leave out of an indenture agreement, because there could be things that you put in your indenture agreement that will protect you, but there also can be things that you put in your indenture agreement which will harm you. And they just gave you 2 examples. If you put in your indenture agreement, you give the power to the beneficiaries to say who the successive trustees will be. They will say you do not really have a trust. You have a partnership. Okay? And if you've been operating in trust for a number of years, they're going to go back all the way to when that trust is formed and tax you for every year you had that trust. Do you understand that?
Okay.
You understand why I'm telling y'all this? Okay? This is why I'm saying this to you. because that is a very small thing that it only takes you a second to put into a contract, but the absence of which will give you a lifetime of pain. Okay.
Yusuf, let me ask you a quick question.
Go ahead.
Your indenture webinar that you did previously, I think it's the indenture question and answer webinar.
Yes.
That particular webinar, would that be something that you would say that would assist us greatly with constructing our indenture?
Yes, it will, but I'm going to give all of you a 42-page indenture at the conclusion. Y'all gonna have a lot of stuff at the conclusion of this series. Y'all gonna have a 42-page indenture agreement. Y'all gonna have the successful management book. Y'all gonna have another book that costs $500. I'm not gonna say it on here, but y'all gonna have a number of different things at the conclusion of this. All right, so you don't have to worry about any of those things. You will have those.
Okay, cool.
Okay.
Is that going to be predicated on coming to all of them?
Yeah, you got to come. You got it. The reason why you have to come to all of them is because I'm gonna break it up in sections. So I don't.
How many sessions will this be?
I'm estimating it's probably going to be about 7 sections, 7 to 8. You know, right now could be more. But it's going to be that we're going to be going through a lot of information, and you know that's why I'm breaking it up in sections. I'm trying to make it affordable. This is not nothing that you can just run through. This is actually like something that you need to go to college. This is like a 6-week course. You understand? You see what I'm saying? So yeah, this is something that you take. This is like a college course that you take. So I'm laying down right now some basic principles for you. Okay, we're starting today off with some case law because I'm giving you an example. I want to start you off by teaching you how to study the subject of trust. Because it's very easy for me to get into giving you a book and then we read directly from the book. All right, but ultimately at the end of the day, if you want to be a trustee, if you want to be knowledgeable, if you want to be like Yusuf Ale or something like that, this is what you have to do. I don't spend a lot of time reading other people's books. A bulk of my time consists of reading case law because everything you ever want to know is in the case law. Even the guys who write the trust books, that's where they're writing the trust books from the case law.
Cool.
Okay? Does everybody get what I'm saying? So once again, recap. The reason we're starting with American jurisprudence, because American jurisprudence, each one of these sentences is a what?
Case law is a statement from a case law.
From a case. All right, you can find that case down here. So right here, let's look at the next one. I'm gonna read a couple of more sentences out of this, and we're gonna go back to American jurisprudence. It says, the case holds that the trustees of a Massachusetts trust are personally liable on all contracts with third persons in the absence of an express or implied agreement with the creditor to the contrary, and that mere knowledge of a provision in the trust agreement that persons having dealings with trustees shall look only to the property of the trust for payment will not release the trustee from personal liability in a case where they have not stipulated against it. Now, what does that mean? Okay, you will see a lot of trust indenture agreements that will have this statement in it, that you are only to look only to the property of the trust for payment. Okay? All right, but what did this case law tell you? It tells you that's not enough. You have to put something expressly in the contract that says that the trustees will not be personally liable. If that is not in your trust indenture agreement, even though you put this provision that you have to look only to the property of the trust for payment, if it ever goes to court, they're going to rule against you because you did not put an express clause in there stating that trustees are not personally liable. Now, when we get this indenture agreement, you're going to see this. Okay, and when you read your indenture agreement, you need to be looking for that. That is a very important clause in the indenture agreement, and if you don't have that in your indenture agreement, you have a poorly drafted trust.
Hey, Yusuf.
Go ahead.
Is that what the bond, you can have the trustees bonded for such cases as well?
You can have a trustee bonded. That is fine. And that's why the trustees are bonded. They are bonded against not performing their fiduciary duty. So what you're saying is, can you get insurance on the trustees? I'm sure you can. Yes, you can. You can get insurance. You can get insurance. Now, if you require the trustees to have insurance, that may or may not attract trustees. Now, here's another thing that you have to contend with. When you are operating a business trust, okay, one of the things that is very important is the trustee. Okay, like for instance, let me give an example of what I'm talking about. This is Correction Corporations of America, which is the largest private prison in America. Okay? When you go over here in our history, you can see that right here, Correction Corporation announces it is restructured into a what? Real estate investment trust. And this is why when you go to, I put their indenture agreement on my website, and I'll show y'all that real quick. This is their trust indenture agreement right here. I took this off of the SEC website, a Securities and Exchange Commission. You see Correction Corporations of America Prison Realty Trust. Okay, they are a private trust also. And right here you can see this is their indenture agreement. Okay, their table of contents. This is a serious ass indenture agreement. All right, but it covers everything. Okay, Correction Corporations, Prison Realty Trust, and Maryland Real Estate Investment Trust, the company. Now, what do they call it? They call it the company, but what is it? It's a what?
It's a trust.
Real estate investment trust.
Okay, so a lot of people are out there giving you the impression that they're operating as a corporation or company, but in reality, they are a what?
Trust.
Trust.
And they don't want people to know it. Now, when you go back and you read this, when you look at the board of directors, now are they a board of directors or are they a what?
Board of trustees.
They are a board of trustees. Even though they are giving you the appearance that they're operating as a corporation, in actuality, they are operating as a trust. And these individuals are trustees of it. And one of them that I want y'all to see right here is this is Thurgood Marshall Jr. All right, Thurgood Marshall was a Supreme Court justice, the first. I think he was the first black Supreme Court justice. And right here, you can see that his son is on the board of trustees for Correction Corporations of America. Now, these trustees, once you see each and every one of them, all of them are experts. They were all like CEOs of other corporations. So if you put something in your trust that these people read that they don't like, then you may not be able to attract a very good trustee to come and be a trustee over your business estate. Okay? So this is another thing that you need to watch out for. So requiring them to have insurance may or may not be something that could be frowned upon. It may or may not be, depending on, how you work it out. Of course, this is all contracts. So, it can be, formed in any kind of way you want it to be formed. All right. Let's see. It says respondents urge that holding of Goldwater versus Altman Super applies only to contracts and that a tax levied by the state is not a contractual obligation. Now, what are these people saying? All right. This is the state trying to tax these people. Okay. They are saying they are trust. And what the state is trying to do, they are trying to tax who? Are they trying to tax the trust or are they trying to tax the trustees?
The trustees.
Trustees.
Okay. The trustees are saying what? You can't tax us. You got to tax the trust. Okay? So this is what they're framing the case. They cite that the old case of Perry versus Washington, a Civil War days case, in which it was held that taxes are not debts within the meaning of the law, declaring United States notes to be legal tender for all debts. So they're saying taxes are not debts. But as aptly stated in 12 California Jurisprudence 1221, The qualities of a debt may, however, by legislative action be made to apply to taxes. Okay, so right here, taxes can be debts. And aside from this, in a popular sense, a tax duly levied becomes a liquidated demand or debt due, and may be embraced with the word debt as used in a statute. We hold that such a liquidated demand or obligation as the amount of a sales tax duly levied by the State Board of Equalization upon a retailer, which is a business trust, is a claim on which the trustees of said business trust are personally liable under the general rule that trustees of such trusts are personally liable for the obligations of their trust, except when specifically exempted either expressly or by implication. This is so beautiful to me. Oh, I just learned so much from reading this case. So what do we have here? What have I learned? Okay, I'll tell you what I've learned. What I've learned is that the state has gone against these individuals for taxes, okay? Right here, the people, of course, the people is the state of what?
California.
California, which is probably their tax commission, okay, going against R&R Cisco and these people are what? This is a what? Trust. And what they're trying to do is they're trying to hold the trustees personally liable and not the trust. And they're trying to say taxes are not debts. And this judge just showed them that taxes are what?
Yeah.
And debts can be what?
Yeah.
Discharged.
Discharged.
Am I losing y'all? I hope I'm not losing y'all on any of this.
Right on it.
I ain't gonna lie, man. I'm lost. How you get discharged out of that?
I mean, it's a public debt, man. It's a public. You know what? I shouldn't even have said that because that went out.
That's right there.
I know that confused you right there. Okay, I'm sorry. Just scratch that last part I said. Okay, I just threw that in. All right. So right there we see.
Yeah.
Now let's look at this right here. As a negotiable instrument by virtue of 3101 of the Civil Code. What is this 3101 right here?
Is that a USC code?
That's UCC. If we're talking about negotiable instruments, we must be talking about what?
That's the UCC code.
So this is UCC what?
3-101.
3-101. How they write it in California, they write it 3101. In Georgia, they write it 11-3-101. It's written different ways in different states, but you will always see these three numbers right here, 3101. So it says, as to negotiable instruments by virtue of section 3101 of the Civil Code, a trustee who signs such, disclosing the identity of the trust for which he was acting, would be, however, exempted from personal liability. So what did we just learn from that sentence?
Trustees aren't liable.
If they do what?
Discharge their debt.
Oh my goodness!
Right.
Y'all tripping. All right, I'm wait a minute. Hold on. Look, y'all. Listen. All right, listen. Okay. All you have to do is read this. Okay. A trustee who signed as such, disclosing the identity of the trust for which he was acting, would be, however, exempted from personal liability. So, if a trustee signs a document and he discloses the identity of the trust for which he was acting, in other words, if you sign a document saying, I'm signing as a trustee for such and such trust, then even if you don't have a clause in your trust indenture, just by the way you signed it, that also did what?
Exempt you from liability.
Do you see how much you're learning in such a short period of time by reading case law?
Yes, I got it now.
Okay. Yeah, have I lost anyone so far? Have I lost anyone?
Nope.
Not at all. Not at all.
Okay. All right. Now let's keep.
But you-
Now see, this is very short. It's only 2 more paragraphs. Any possible showing of exemption in the instant case should properly be made in an answer. The amended complaint alleges all the necessary elements to constitute the liability. A plaintiff need not negative a defense founded upon an exception to a general rule. The general rule is that trustees of Massachusetts Trust are personally liable for the obligations of the trust. The demurrer should have been overruled. The judgment is in favor of respondents individually, is therefore reversed, and the cause remanded with directions that the demurrer be overruled and suitable time given them to answer the amended complaint. So, what just happened? This is an appeals case. Can anybody tell me who lost this case?
The people?
No. Read this again.
No?
The individual.
Okay.
I would have had the wrong answer too. Don't worry about it.
Okay. And this is okay. This is okay because it just shows a need for you to develop your vocabulary as it relates to legalese. All right. It goes and says any possible showing of an exemption in the instant case should properly be made in the answer. In other words, if they didn't put it in their answer, they should have put something in their answer saying how they were exempt, and they didn't. The amended complaint alleges all the necessary elements to constitute the liability. In other words, the amended complaint that these people put in, they amended their complaint, they showed where they're liable. These people did not show where they were not liable. Okay? So it says a plaintiff need not negative a defense founded upon an exception to a general rule. In other words, there's a general rule already now in place that trustees are personally liable for the obligations of the trust. The only way, that's a general rule of Massachusetts Trust, that the trustees are liable. So they don't have to, the plaintiff doesn't have to say anything because the general rule is already there. They don't have to prove anything. So it was these people's responsibility to show how they were not liable, and did they do that?
So if they had put that in their indenture, would that have made a difference?
Right.
It would have made it would have made a difference, but they should have also alleged that also in their answer, and they did not.
Wow.
So basically, whenever we sign something from now on, whatever, we got to take into consideration the principles of this case by about keeping us different from the straw man or the fictitious part. So, like on your driver's license, whatever, if you do get one, you sign by whatever, or you put agent.
And that's why they're not letting y'all sign those driver's license like that now either.
Or your passport, you put by, or you put agent or representative like that. So, okay.
Exactly.
What are they not letting you do as far as your driver's license?
They ain't letting you sign and say that you putting UCC 1-307 and all that on there.
Yeah.
They're not letting you.
Actually, a friend of mine actually did just get away with doing that.
He was. You said the right thing.
He got away with saying no rights reserved. All rights reserved.
Okay, well, you said the right thing. He got away with it.
Right.
So basically, what we need to do basically is go back and recontract with these people by putting our administrative process by rebutting everything and correcting all the presumption.
And that's why they do that, because you got to understand that you have to learn how to sign your documents without liability. And let me give you something real quick, okay? Because this is why you are forming a trust is because you are trying to get rid of liability. Own nothing, control everything. Ownership means what?
Liability.
Liability.
Now, Yusuf, when you do sign, if you just by putting by, that doesn't specify that you're a trustee. It just specifies that you're something.
Well, it shows that. Well, what the UCC says is that. Let's look at the UCC. What the UCC says.
Yes, thank you.
Right. Because the UCC tells you what it is. It tells you.
So all contracts we do should be like, show that we're not the actual person.
Responsible party. Reliable party.
Not only is the signature important, but how we sign is important.
Yes.
How you sign is important. All right.
Are you going to go over like what a trust can do versus what a business can do? So we don't.
They both can do the same. They both can just about do the same thing. I mean, it's just that it's the tax liability that is associated with it, because when you are a private trust, you're tax exempt. All right. You're in total control of it because the trust is a creature. They doing both basically the same thing. They operate largely exactly the same with some very with a couple of differences. One of them being that a trust is, terminates as a termination date. All right, that's one of them. But there are a lot of similarities between a trust and a corporation, and I'm going to be going through those in just a second and talking about that. And we're going to address all of that. Trust me, we're going to go. Y'all just be patient. I'm not going to rush through this.
All right.
I'm not going to run through everything for y'all. Okay, that's why these are $25 webinars. We're going to concentrate on different points. Every time that we have one of these webinars, we're going to be concentrating on something. All right, so y'all can get a lot from this. I got to take my time and walk you through this, because what I'm attempting to make y'all do is be trust experts, not just leave here with just a little information about trust. Okay, you got to understand what you are doing when you're dealing with a trust. I mean, just in that one case right there, what did you learn? Let's do a recap. Okay, somebody give me 4 things that they learned from the case that they just read.
What not to put in the trust?
Okay, stop. What should you not put in a trust?
Something where the beneficiary takes over the trust as trustee.
I'm sorry, what'd you say?
A clause in there that would allow the beneficiaries to make a power move over the trustees.
Great, exactly.
Right.
Okay, give me another one.
The trustees
I learned that you were endangered.
Clause.
I'm sorry, go ahead.
That trust and businesses are very much similar, but the trust are tax exempt as opposed to a business.
Okay, well, a trust can incur a tax obligation, but yeah, fundamentally it's tax exempt. The only reason a trust is tax exempt because everything private is tax exempt.
Right.
But that does not mean that something private cannot have a minimum contact with something and incur some sort of tax liability. It doesn't mean that. All right, that's why we're studying this, okay? A trust fundamentally is tax exempt because it's private. Okay?
So you're saying by default everything is tax exempt except if you do something that creates a minimum contact.
What kind of law is tax law?
Public law.
Public law.
Basically.
Let's look at this.
Don't forget the UCC though. Go. Don't forget to.
As a trust, can you like buy and sell property?
Yes, you can buy and sell property. I just said you can do everything.
Right.
A trust is a person. It can do everything. It can buy, sell, hold property, everything. Yes. Why do you think we're trying to teach you how to operate through a trust? You can do everything.
This is so foreign. This is foreign information to me. It's really mind blowing.
Yes.
Not mind blowing, but yeah, I'm just was not familiar with how trusts were run.
Yes, it can do. It is called a person. Okay. See right here, public law. Public law is what? Public law comprises constitutional law, administrative law, tax law, and criminal law. So where is tax law on what side? The public side. So if you're on private, does this apply to you?
No, sir.
No.
So do I have to claim my nationality to be tax exempt?
No.
You have to be what?
Private.
Private.
I mean, this is just so exhausting. I can't even believe I have to go through all this just to show people this stuff. I mean,
Yeah, this is forcing us to reprogram the way we think.
Yeah, Yusuf, you got to work with us, man.
Yeah, it's just we've been programmed, you know.
Yeah, we got to be trained because you got to think we've been ingrained in this system.
We've been in the Matrix so long.
You have.
Right. We don't know if the pill is blue, purple, or red.
we're just getting unplugged.
Yo, I will say this though. Yusuf, about I just went and checked it out last night. Me and my queen, man. That John Wick, bro, and what you talking about right now in this trust law with the public and private. That's all replete through the movie.
Yeah, it is, man. Ain't it, man? John Wick. The only time you see Federal Reserve notes in that movie, they burn them.
Yeah, exactly.
What's the name of the movie again?
Yeah.
What kind of, how are they doing their business in that movie with what?
Gold coin, baby. Gold coin, and honestly, through, you know, kind of like just that general rule that's kind of written but not written. You know, you coming over here handling this public stuff in the private setting, and you breaking the rules.
You breaking the rules. You can't bring exactly. You can't bring anything. They got rules and everything. Everything got to remain private. And if you violate that privacy, you're gonna end up dead.
Yeah. And if they violate yours, you get a reward, a gift.
You get a reward, but everything was conducted privately.
Yeah.
They did not involve, if some people got killed, they didn't call the police. They had somebody else who would come in privately and clean up everything. And they would pay him in gold. Everything operated in gold. That movie was so cool. I mean, that was a cold-blooded movie.
Yeah, I got to go back and watch it again after this. That was the plan, so I can break it down further for myself, because it's a lot of knowledge in that.
It was a lot of knowledge in it. Let me show you this real quick. Everything goes back to this right here. This is why I'm always showing. John Wick. That's the movie we're talking about, John Wick. Okay. Let me go back to this right here. This is why I'm always giving this to you. This is why in order to understand any and everything that we're talking about, you have to understand this one-page document right here. I'm always giving it to you. It's public and private outline. This is why I'm always giving you this, because when you understand the public side is what? Constitutional law, criminal law, administrative law. I don't have tax law over here, but tax law is over here. And private law is what? Contract. What is your trust? It's a what?
Contract.
Okay, so contract falls under what?
Private.
That's why they say contract makes the law, because this over here is the only thing that has any kind of law contained in it is contract. So they say contract makes the law. You don't see no other laws over here. Over here, you'll see administrative law, criminal law. These are all statutes. Constitutional law, you don't see that over here. The only thing that you see over here that really comprises some sort of codified law is contract and tort. And tort is the result of an injury. So it's contract makes the law. It's the contract, okay? That governs everything. It governs. That's why over here in the Constitution, they got a clause that they can't create a law that will infringe on the obligation of contracts. Because this right here is to hold them back from coming over here. Public and private. All right, so let's get back to discussing trust. What I'm going to do is I'm going to take.
Can you go back to the UCC, Yusuf, and just show us that for signing?
Oh, yeah, okay. And what it is let me do it like this. I'm going to do it like this. You're right.
Now, which Crack in the Code book is this?
Three.
Two?
Three.
Okay. Is the link to one on your website too?
I'll put it in the Dropbox. I don't have Crack in the Code 1. I don't think I ever read 1. When I first came into this, they were on 3, and that's the only one I've really ever read. I haven't really gotten into the other. All right, this is what you want to read. It's on page 350. You see it right here of 592. How to sign your signature without liability. All right, so right here, when you get into this, which is very, very good, the key entry point into Article 3 of the subject of signatures is this, 3-204. The general rule is that a signature is an endorsement if the instrument does not indicate an unambiguous intent of the signer not to sign as an endorser. Intent may be determined by words accompanying the signature, the place of the signature, or the circumstances. So right here, this is what they're talking about in the court case. When you sign your name, you have to make it expressly understood in what capacity you are signing your name. And if you don't, what your intentions are. And if you don't do that, then some contrary general principle may apply. Like in the case of the trust, is if you don't expressly sign your name that the trustee is not liable for any contracts entered into by the trust, then the general rule of Massachusetts trust is that the trustee is liable. So I want you to write down UCC 3-204. Write that down. Endorsement. Okay, endorsement means a signature other than that of the signer as maker, drawer, or acceptor. So if you sign it and you're not signing it in the capacity of a maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of 1, negotiating the instrument, 2, restricting payment on the instrument, or 3, incurring endorser's liability on the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument placed on the signature or other circumstances unambiguously indicate that the signature was made for a purpose other than endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. Okay, and basically all that is a very fancy way of saying you need to be very clear and cogent of how you are signing the document and what capacity you're signing it as. Once again, that was what this case was all about. This case was all about liability. Were the trustees liable or were they not liable? They entered into a contract. It wasn't because whether or not the taxes were a debt or not. That was a moot point. What came out at the end was, did they expressly indicate their intent and what capacity they were going to engage in the contract as a trustee for the trust. And as I said, you should always put in your indenture agreement that you don't have liability, but you also need to sign the documents as trustee for such and such trust. Does that make sense?
Yes.
Yes.
Okay.
Okay, one more question really quick on that UCC 204. So the UCC is negotiable instrument. So does that apply? Does that explanation apply?
Everything that you're operating in is in commerce. Everything is in commerce.
So if there's a letter or something and you're signing it as the trustee, does this apply?
Yes, it would apply if it's a contract. If there's going, let me put it like this. If
because it says
wait, listen to me. Listen.
Okay.
All right. This is about liability.
Mm-hmm.
Okay. If you don't want liability, you need to be very clear how you sign a document. Because this was about a debt collection. Okay. This case we're going into is about a debt collection. It was a commercial contract that was entered into about money. And who was going to be liable for the taxes on it? Was it going to be the trust or was it going to be the individual trustees? And a principle of trust law, if you don't sign that instrument clearly expressing your intent, and this should be for everything. When you read 3-204, I know you're talking about negotiable instruments, but everything that we're operating today is commerce. Every time you sign your name on something, it could be a negotiable instrument. You don't know.
Okay, so that's why I wasn't clear about that, because everybody goes back to the UCC, and the UCC is about instruments, and is everything an instrument? That's the question. Yeah.
And that's why they have a word called fraud in the factum. Because fraud in the factum means that you signed a document and you weren't told that it was a negotiable instrument. And that is a major problem that most people have today, is that they think a negotiable instrument has to look like a check or a money order or something like that. And they don't understand that a application for a car is a negotiable instrument, or, just a number of different things are actually negotiable instruments. You just won't know it's negotiable. A negotiable instrument can look like a letter.
How do you know?
But by studying the UCC and understanding what all the necessary elements need to be present to make it negotiable.
An account number.
Like, for instance, isn't a letter of credit a negotiable instrument?
Yeah.
Yes.
It's called a letter. Isn't a birth certificate a negotiable instrument?
Yeah.
Isn't a car title a negotiable instrument? Don't you take it to the pawn shop and get money for it?
Yeah.
Yeah.
Do I need to go on?
So you said on that authorization of credit, if we put non-negotiable on there, does that stops it from going any further? Correct.
Put what on it?
If you put non-negotiable on it, that stops it from going any further.
That's not. That, to me, in my opinion, that's not stating and what it's not stating liability. That's not addressing the liability on it, because you put non-negotiable on it. We're talking about liability right now. You need to put in there what we're talking about. First of all, let's be clear. We're talking about trust right now. And as a trustee, when you engage in contracts with third parties, every time you sign that contract, you need to sign it as so-and-so L in the capacity as trustee for such and such trust. Is that clear? I don't think we need to make this any more complex than it needs to be. Okay?
It's clear.
I started off showing you a case law of how you can get in trouble just because you do not sign a document a certain kind of way. There's a case law for almost every situation you could possibly find yourself in as it relates to trust.
Yusuf, may I ask a question?
Yes, that's what the class is for.
Well, just real quick, I'm going back a little bit. On the CCA trust that is acting or doesn't want you to know they're a trust, or any entity, is it defined that they must put the word trust in there, even though?
I'm gonna tell you no, and them people at the IRS are doing stuff they ain't supposed to be doing. Because I'm gonna show you the court case, and it's in here. I ain't got to it yet.
Okay.
Can you, as opposed to even putting your name, can you just sign the actual name of the trust? Like, say if I started Sunshine Trust, so they want the signature, could I just put Sunshine Trust?
No. You got what? Okay. Who are you? You got to sign your name. The trustee has to sign his name. You're a trustee. A trust can't sign something for itself. All right?
Got it.
You have to sign it. Okay? You're going to sign it in the. You don't have any liability. You don't have to worry about signing your name on it. All you need to do is sign your name and state that you're signing as trustee for that trust. And then make sure you put in your indenture agreement that you have to look to the trust corpus for it to satisfy any type of liability, not to the trustees. How complex is that, y'all? It's very simple. Okay? Just that. Make sure those two things are present as a trustee. Make sure you have in your indenture agreement that contracts entered into by the trustees, they won't have any liability. And when you sign your name on something, sign as so-and-so trustee as for such and such trust. That should be easy for everybody to remember. Okay? Let's not make it any more complex than that. All right. You're going to get to a point and you're going to see all of this. Now, can we continue? Because people have paid their money and we got about 2 more hours left. What I'm going to do is I'm going to take a short 10-minute break. And when we come back, we're going to continue. Okay. All right. And we're going to go through Heck versus Malley. We have to go through Heck versus Malley because you can't even call yourself a trustee if you haven't read a case like Heck versus Malley. You can't even really say you know trust, I would think, properly. Okay? All right. Is everybody rolling with me? Am I confusing anybody? Does everybody understand what's going on? Is anybody lost or anything like that?
Yeah, we're just new, but you're breaking it down good.
Okay. All right. Okay, great. Take a 15-minute break, and when we come back, we're going to continue.
So maybe someone else can answer while we're on break about the birth certificate. We're the beneficiary, or are we actually a trustee of that?
Beneficiary.
Blakemore saying both for that.
Hello, everyone. Welcome to our Tuesday Q&A with Lynette Zhang, our Chief Market Analyst, and myself, Eric Griffin. I'm the President of ITM Trading. And for those of you who don't know or are just tuning in for the first time, we do this live Q&A every week. And I take questions from either our email, Facebook, sometimes Twitter, and the YouTube comments section, and I aggregate them here on a one sheet. Today we have a couple of questions, and there's one question that I asked her to be ready to talk about today because there were so many comments all over from our email, Facebook, Twitter, and YouTube about this particular piece on House Bill 5404. So we're going to talk a little bit about that today as well. But we're going to start with BC.
Okay.
Asks, and this is a multi-part question, so I'm just going to ask one at a time.
Okay, good. That's helpful for me.
Right.
Okay.
All right. So Venezuela has done the reset of its currency to gold. Does this mean that the reset is dependent on each country's government and only those facing a crisis like Venezuela?
Well, yeah. Actually, each country will have to do it, though I do think we're going to get a global reset that happens. But historically, there has never been a global reset that's happened before. Even during the Depression in the 30s, and now we're completely interconnected. But even back then, when we went into a depression here, there was a global depression, but it wasn't so much because of the interconnectedness. So typically it will be like one country and then the countries around it sort of gang up on them to really kind of take them down. But this time is different because it's based on the foundation of the system, which is constantly compounding debt, not being payable, and the tools that they had to keep that going, interest rates, and the ability to keep growing debt, where they don't have those tools anymore.
So then question, so do you think it'll look like, let's say, one country, a big country, the UK or something like that, and they're the first and it triggers like a waterfall crescendo? Or are you thinking more like, okay, the IMF says they determined that we're at this breaking point and this is the solution, we're gonna reset everything right now?
Yes, I think it'll be more like that, but understand that everybody is going to have to be in enough pain in order to accept the medicine that they want us to swallow.
Because we're going to take a bath, right?
Oh, yes.
Yeah.
Well, look at Venezuela, okay? We are not going to be immune from that. Globally, we're not going to be immune from that. So I do think that it's going to start with a market meltdown. And whether what we're going through right now is part of that market meltdown or it will just be, it'll come from a black swan event or a war event or something like that. But it will definitely be tied to a major market meltdown that is going to impact the already extraordinarily precarious retirement system globally. I mean, we're all dealing with the same issues. So it's going to be really scary, but I think they're going to come out and do a global reset through the IMF, because the IMF, since their money is truly created out of thin air, okay, they have no debt on their balance sheets, or they have the cleanest balance sheet anyway. So, yeah, it'll be orchestrated by the shift by the IMF, but nobody's immune.
Okay. Will there be, second part of the question, will there be an eventual reset on a global level such that all currencies, well, we just kind of talked about that.
Right.
We answered it.
Right. And as far as all currencies, when the IMF rides to everybody's rescue, the SDR has been slated to be the world reserve currency. Okay, so we'll have, at least at this juncture, and according to what I'm seeing from the Biz Money Flower, you're still going to have local currencies, but then you're going to have one global international currency. So where the US dollar is primarily that global international currency as well as local, will just be local.
And so I noticed that at the end of this question it says, will all countries reset their currencies to the fundamental value of gold? I think we've talked about in the past that you think only gold, if the IMF does it, only a portion of their currency will be pegged to gold, right?
Well,
only a certain element.
Those
of
are
it.
two different questions.
Okay,
actually. As far as do I think there will be a global reset where all currencies reset to gold, the answer is absolutely yes, because that's the way they do a reset. Okay, now Venezuela is not done yet, clearly, but this gives us a real-time opportunity to see when they reset the mortgages, and now they're lopping off zeros, and they're doing all of these different things that we find.
Or if you want to call it a trust law, one of the tenets of trust law is trusts have to have termination dates. I didn't write the rules. Okay.
Yeah, I was just wondering why the rule was created in the first place. That would explain.
You probably have to go back into the study of trust and the Salmon. Okay, this all went back to the church and the king, where the king would get the property when somebody dies. It's called the law of escheat. When something is, you know what an escheat is?
Right. Yeah, I remember that. Yep.
Okay. Well, what was happening is that the property would automatically escheat back to the king. So what they had to do is to prevent, the king from getting the property. The church was the first place to do this. The church put everything in. They created these trusts and put everything in trust, so they didn't own property. And when somebody died, he couldn't get it because the property wasn't in their name. This is how all this started. It started back in England and some of these places where it was all due to them trying to avoid this escheat of property back to the state. Today they don't call it the king, they call it the state. Back in England, it was the king. In our country, the state has taken the place of the king. It's public. In England, the public would be the king. In our country, the public is the government. Everybody get that?
That's deep. Yeah.
Does everybody know what escheat is? And did everybody write down that doctrine of merger? Does anybody not understand this doctrine of merger? Okay. You can be a trustee and a beneficiary of a trust as long as you are not the what?
Executive trustee.
Sole trustee.
Sole beneficiary.
Right.
So you said sole beneficiary or sole trustee?
Sole trustee. You can't have a trust and you be the only trustee and the only beneficiary.
Right.
You don't have a trust. And here's another thing. There can be multiple trustees and multiple beneficiaries, but they can't be what? The same trustees and the same beneficiaries. So if you got 3 trustees and 3 beneficiaries, both. It can't be the same 3 trustees and the same beneficiary. Everybody understand that?
Mm-hmm. Mm-hmm.
If you do that, they're going to terminate your trust, and the beneficiaries are going to own the trust property. Now, and it's cheap. You need to write this down. It's cheap. It's a common law doctrine which transfers the property of a person who dies without heirs to the crown or state. Notice it said crown or state. Remember, I was just telling you that in England it was who? The king. In our country, it's what? The government. So when somebody dies and don't have any heirs, it would escheat back to the state. It serves to ensure the property is not left in limbo without recognized ownership. Okay, and this is what they were trying to avoid.
In the break, we were talking about when people assign the judge as the trustee to the birth certificate. Is that what keeps it from not being terminated, that the government is a trustee, or are they actually a beneficiary?
Well, actually, what's happening is it's a public charitable trust, and you are serving in the capacity as a beneficiary and a trustee. You're like a co-beneficiary and co-trustee. You act in the capacity as a trustee when you sign documents and do all kind of stuff for the straw man, don't you? And then at the same time, you're a beneficiary because you are the beneficiary, you're the holder of the trust certificate. So you're acting in both capacities, actually. That's why I was bringing up this thing of doctrine of merger, to let everybody know you can be both a beneficiary and a trustee at the same time of a trust. A lot of times, those positions are always flip-flopping back and forth. That's why when you go into court, where Judge Dale was talking about you, did everybody read that Judge Dale document where he was saying when you go into court, you appoint the judge as the trustee? Because what's going on in court...
That's unlawfully you. I was just telling him about it. I think that's the same document. Unlawfully yours or something? Or lawfully yours?
It's called Judge Dale. It's on my website. It's...
Judge Dale's, no, that ain't Judge.
It's this one right here. The Great American Adventure.
Oh yeah, that one too. Yeah, there's another one called Unlawfully Yours as well. It may be the same judge though.
Yeah, it is the same judge. He writes a couple of documents, right. And in here he gets into a discussion about what happens when you go into court. I don't think it wasn't this document. It wasn't Adventures. It was you got another one on here, the Great American Adventure, and the other one is The Matrix and You. This is it. This is Judge Dale too. The Matrix and You. Now, this is the first time I ever... Well, you see right here that they didn't put his name, but later on he started putting his name on it. See, during my 12 years as a judge, this was the first time I came across this. And I think it's on page 14. You'll see where he gets into, this is a very good document to read too. Very good document to read. You'll see right here. He said, first, the sovereign must inquire that we're on the record or not, blah, blah, blah. Secondly, all the sovereign has to say for the record, I am a beneficiary of the trust, and I'm appointing you as the trustee. This works. When you go into court, it shakes them. I'm telling you. I tried this. Yeah. It shakes them to the...
And when you ask them for that 1040 too.
Ask them for that 1040. Because see, this is who goes to jail. You got to think, y'all.
Trustee. Exactly.
Really, the trustee is the one that goes to jail because he has the liability. He has the fiduciary duty to perform. So if they are saying that you are the if you go into court, what they're saying is they're drafting you for performance. And they are looking at you as the trustee with a duty to perform. And if you don't perform it, you are in contempt and they are going to hold you in jail. But this is a presumption that you are the trustee. All right? You have to expressly state that you are not the trustee. You are the beneficiary of the trust, and you appoint him as the trustee, and then you direct him. You start expressing what they call expressing the trust. This is what Winston Shrout did. Did y'all read the Winston Shrout response? Winston Shrout, in his response, he expressed a trust and appointed the judge as the trustee. He did all of this.
That was nice.
Exactly.
Oh, he did. Oh, he did. I didn't get any.
You didn't get what?
I didn't hear any results from it, so I had no clue on what the result.
I haven't heard any. And you probably, if he has any type of success, you probably won't.
Well, I know, right?
I mean, that's what another thing killed me about people. Y'all really looking for them to
really tell us, right?
Yeah, to give y'all some sort of public confirmation that everything that y'all doing is correct. Are you really looking for that?
Yeah, it's probably not going to happen.
It's going to be held. If anything, it's going to be held. It's going to be taken care of privately.
Yeah. Yeah, because I noticed like when basically now everything got quiet after the.
It got very quiet. It did.
Yeah, I started laughing at that. I'm like, you know what? It's like they took down out the news, out the papers. It went completely quiet because now, since he did that and the document was public, it put everybody on the spot. They're like, okay, hold up, we done messed up. You know,
you done messed up. That was a very well. That's why I put it on my website. I read. I'm like, damn, Winston got down on this. Here it is, right here. This is his response. When I read it, I'm like, y'all heard me when I read it over the air. I read it over the air. I said, damn, and then he came back, and I did that before he did the interview. He came back and said, y'all expressed the trust, and I read this. This is under this case law right here. This is his. When you read this. And it's well worth looking at right now. Winston Shrout response right here. And you can see him. He said he's a third-party intervener. That comes from Rule 24 under Federal Rules of Civil Procedure, having terminated the previous fiduciary to the corporate entity ens legis, a documented vessel under United States Registry, otherwise described as Winston Shrout, or any alphabetical or numerical variation thereof, also known as defendant, Nuc Pro Tunc, the 4th month, 27th day, 1948, which is his birthday, said entity having as its trustee the Secretary of Transportation of the United States. Now, we know that we have discharge through the Secretary of Transportation too, okay? And there being no living sentient being responsible to accept service. Do y'all know why he talked about the Secretary of Transportation?
Because like he's over commerce.
Okay, hold on.
The body as a vessel.
Mm-hmm. The Secretary of State is the bookkeeper.
He's the public official over like all the commerce, whatever, you know. So you know.
Hello, everyone. Welcome to our Tuesday Q&A with Lynette Zhang, our Chief Market Analyst, and myself, Eric Griffin. I'm the President of ITM Trading. And for those of you who don't know or just tuning in for the first time, we do this live Q&A every week, and I take questions from either our email, Facebook, sometimes Twitter.
Are you looking for an opportunity to earn a substantial monthly income while helping business owners obtain financing? Then Go Capital's broker referral program is for you. As a registered broker, you'll have access to a variety of business loan and real estate financing programs for clients nationwide. You'll also receive all the training, marketing, and sales supports you'll need to quickly start earning commissions. All this at no cost to you. Why is this such a great opportunity? With approximately 30 million active small businesses in the U.S. and banks limiting access to traditional commercial financing, loan brokers offering alternative funding are in very high demand. You can easily earn over $10,000 in monthly commissions by offering loans from $10,000 to $5 million. Go Capital services include revenue-based loans, equipment leasing, business lines of credit, unsecured term loans, commercial real estate mortgages, and more. With us, bad credit, tax issues, and high-risk industries are not a problem. Whether you're an accountant, banker, realtor, no business owners, or simply want to enter the lucrative field of alternative business lending, our broker referral program is designed for you to succeed. Join the Go Capital team and start earning today.
That's why I'm trying to teach y'all how to think. Okay, you don't have to follow no guru or nothing like that. Once you understand the principles that are involved in everything that's going on and everything, you'll see that's why it is necessary for you to understand trust law. When you begin to understand trust law, you can listen to somebody and like, man, why are you saying that? I mean, that's why I teach from case law. I teach from case law because I want all of these loudmouths to argue with the judges and not with me. See, I've been doing this a long time. So I've already gone through all this. Well, now he's not right in saying that. I got sick of going through all of that. I said, you know what? I'm not even going to go through this anymore. Because I know most of these so-called cats out there, they don't even know how to read a case. They can't read no case. How many people are coming on the air reading an entire case to you and breaking it down?
Nobody but you.
That's what I'm saying. And they try to downplay it as if it's not necessary. Then in the next breath tell you that all roads lead to court. If all roads lead to court, then why aren't you reading case law to see what the precedents are? The case law tells you how the court decides cases. That don't make no sense to me. Not to me. The only reason they're saying that is because they've never read case law. That's like a person telling you that you shouldn't fast, that you fast, you might die, or you might need, you're not getting the necessary protein or something. The only person that says that is a person who's never fasted before. They don't know what they're talking about. Fasting is the most beneficial thing you can do for the body. All right? Okay. Now, are there any questions so far? I don't want to get too off base. Let me finish this right here. I want to finish the differences.
Is that what you were just referencing on your PDFs, that Winston Stroud response to indictment?
Yeah, that's right there on my, it's not under PDFs. It's under case law. This is case law. You're going to click on case law. Click on case law, and then these cases and what I did is I separated. I got private trust cases. Look, I got Hick versus Malady, Dunbar versus Redfield. These are all the cases that you should be reading. And as a matter of fact, this is the homework I'm going to be assigning. Your constitutional questions, your mortgage foreclosure cases, lawful money discharge cases where people went into court trying to discharge cases. And right here, that's the Winston Stroud 2016 response to indictment. I put it right there. This is the indictment where they indicted him, and this is the response to the indictment that he put in. And that's all he needed to do. Now, how it goes for him, and if he know how to handle himself, I don't know all of that. But I'm trying to let y'all see where this stuff is coming from. Let's get back. Okay, we're going to continue about some of the differences between a regular trust and a business trust organization. Okay, in a regular trust, the grantor transfers property into the trust by a gift or for consideration, which grantor conveys back to himself, not in the ordinary course of business and not at arm's length. Okay, now, arm's length is a word that I want y'all to write down because we're going to be discussing that at length. Arm's length means this, that as a trustee, you cannot do anything for yourself. Everything that you do for the trust has to be for the benefit of the beneficiaries. If you do anything for yourself, it's going to be considered that it's self-dealing, and then they're going to collapse your trust and then construe it as something else other than a trust. Okay? When you look at a business trust, the exchanger exchanges at arm's length property for capital units in the ordinary course of business. Okay? And in the last one, the last comparative difference between an ordinary trust and a business trust organization, okay, in an ordinary trust, the certificate holders are the principals in a partnership agreement. The trustees are managing agents. Certificate holders hold an interest in trust assets. There are no special tax advantages. So in an ordinary trust, you don't have what? No what?
Tax advantages.
So you have all the liability. This is why we don't deal with living trust. All they're doing in living trust is they're trying to avoid probate. All right? You're not getting any real benefit or any real privacy by engaging in certain statutory entities. So right here, in a business trust, the capital unit holders have neither a voice in management. Who are the capital unit holders? What's another name for capital unit holders?
Shareholder.
Shareholder, beneficiaries. The beneficiaries have neither a voice in management. What does that mean? They cannot tell the trustees what to do. Nor do they have any ownership interest in the assets. So in an irrevocable trust, the beneficiaries don't have what? Ownership. And that's why you want it, because you don't want, with ownership comes what?
Liability.
And you don't want any what?
Ability.
Their only rights are to receive distributions of profits when and if they occur, and to receive distributions of assets upon dissolution should that ever occur. Now, what does that mean? When a trust ends, everything in the trust goes to the beneficiaries. This is why you have people like Patrick Devine and some other guys a couple of years ago. Everybody was trying to collapse the trust. And collapsing the trust, what they are doing is, and it's a principle of trust law, that when you collapse a trust, all of the assets go to the beneficiary. And if you are the beneficiary, all the assets come to you. So what they are attempting to do in the redemption movement is collapse the trust, because all that money that is in it, they're trying to get it and then put it in another trust that they have control over. Is anybody confused on what I just said?
Right? That makes good sense.
Anybody confused on that?
Nope.
The entity is controlled by adverse trustees who irrevocably own property in fee simple. Special tax advantages can be realized with proper planning and application. So let's read that last sentence again. You do have special tax advantages, but only if you do what?
Proper planning.
And?
Application.
Okay. So do you automatically get a tax advantage with a business trust? No. It's how you manage the trust that's going to give you your tax advantages, because you can possibly engage in conduct that could possibly make the trust liable for a tax. Okay. Does anybody have a question on what I just read?
That conduct would be like a beneficiary telling the trustee what to do and making it look like a partnership, for example. Would that be correct?
And we're going to talk about this now. We're going to talk about trust or association, and we're going to talk about classification of organization for tax purposes. Okay? Distinctions between ordinary trust and business trust organizations for what? Federal what?
Tax purposes.
So we are trying to be what? Tax exempt. You're becoming a beneficiary. You're trying to own nothing and control everything. You're trying to be completely what? Private. Nothing is in your name. All right? You don't have an ownership interest in nothing. All right? Everything is operating through trust. So the tax advantages for this. So let's explain. Let's go through this. Person. The term person includes an individual, a corporation, a partnership, a trust, or an estate. Remember earlier, the gentleman asked me, what can we do with a trust? A trust is considered a what? A person. It can sue and be sued, hold property and convey property, just like anybody else. Is anybody confused on that point?
No.
No, sir.
Okay. Such a term also includes a guardian committee. A committee is called a person. A trustee is a person. An executor is a person. An administrator, a trustee in bankruptcy, a receiver, an assignee for the benefit of creditors, conservator, or any person acting in a fiduciary capacity. Standards. The Internal Revenue Code prescribes certain categories or classes into which various organizations fall for purposes of taxation. These categories or classes include associations, which are taxable as corporations, partnerships, and trusts. The test or standard which are to be applied in determining the classification in which an organization belongs, whether it is in an association, a partnership, a trust, or other taxable entity, are determined under the Internal Revenue Code, 301.7701-2, and we're gonna read those. I'm gonna take y'all to those because you got to be familiar with this. All right, so I want you to write down IRC 301.7701-2 and to 301.7701-4. Let's stop and look at that for a second because it's very interesting.
Hello, everyone. Welcome to our Tuesday Q&A with Lynette Zhang, our Chief Market Analyst, and myself, Eric Griffin. I'm the President of ITM.
Lawful money discharge cases where people went into court trying to discharge cases. And right here, that's the Winston Stroud 2016 response to indictment. I put it right there. This is the indictment where they indicted him, and this is the response to the indictment that he put in. And that's all he needed to do. The business cannot be deemed an association of the shareholders as contemplated by a statute providing for suit, attachment, and service of process against an association as if it were a corporation. So right there, you see, this is why they underline this. This right here is telling you, is giving you what you have to do in order for your business trust not to be considered an association for tax purposes. Okay? Once again, we get into corporations, okay? It is generally held so far as pure legal principle is concerned, and apart from any declaration to the contrary in statute or constitution, that a Massachusetts or business trust is not a corporation, insomuch as there are obvious, important, and fundamental differences between the two types of organizations. But while a business trust is not a corporation, it has some of the attributes of a corporation and is similar in its practical effect. Thus, the corpus of a trust corresponds to the capital of the incorporated company. So this right here is a similarity between a business trust and a corporation. The trustees to the board of directors. Remember, we're talking about a corporation has a board of directors, a trust has a what? Board of trustees. The beneficiaries to the stockholders. In a trust, you call them beneficiaries, and a corporation, you call them what? Stockholders. The beneficial interest to the shares of stock and the declaration of trust to the charter. So in a corporation, you call it a charter. In a trust, you call it a what? Declaration of trust. Okay?
Yes.
And it go, man. I mean, this. I could have teach the whole class out of this. All right. It goes on. It says business trusts are sometimes and for some purposes by constitution or statute placed in the same category as corporations or by definition classified as such. But the fact that such a trust is regarded as a corporation for certain purposes, for example, for the purpose of determining the individual liability of the members or trustees, does not mean that the corporate analogy will be indiscriminately applied or that the organization will be treated as a corporation for all purposes. And such provision has been held not to render illegal a business trust on the ground that it was a corporation within the definition and did not comply with the statutory provisions with respect to corporation. And then partnerships. It is often stated generally that business trust is not a partnership. and that the members or shareholders thereof are not partners. But while there are essentially differences between a business trust and an ordinary partnership, certain courts have stated generally that business trusts are partnerships and that the members or shareholders thereof are treated as partners. Now, what do they mean by that? They gave you a case. When you go and read that case, what you're going to find is why they construed a business trust as a partnership. And it was because something, see, he said, holding that all shareholders as partners must be joined in an action by or on behalf of the trust. And let's see, one of the principal features distinguishing a business trust from a partnership is that in the former, the legal title is in the trustee with certain equitable or beneficial rights in the others. All right, so when you read all of this down here, it's going to tell you the differences. This is why you read the cases. Crocker versus Malley is another very important case involving the liability of shareholders for debts. All right, and whether or not the beneficiaries, when the beneficiaries start acting as a partner with the trustees, then the beneficiary can be held what? Liable. But the whole point of being a beneficiary is to avoid what?
Liability.
Okay, I'm going to stop right here and answer some questions.
So, Yusuf, as we go through our secure party process, and we gain our 9-8 numbers and all of that good stuff, and we establish our all capital name as the trust, then basically we need to go and set up another trust to operate the business, like you did with the high frequency trust
for your property. And then, see, the reason I'm teaching y'all business trust is when you become private, you got to learn how to live your life through trust. Okay? A holding trust is not going to do that. A living trust is not going to do that. Those type of trusts are not going to help you live your life through trust. Okay? You got to learn how to do business through a trust. That is what, and the problem with the average people out here, the reason they can't do it is because there are no trustees. All the people who know how to do this are helping very wealthy people, and they have special schools where they teach this to them. So the average Blow Joe on the street does not have access to this type of entity because there isn't anyone that knows how to be a trustee over it. So this is why I'm teaching y'all this, because in your security, you're going to get a 9-8 number, which is a private number. That is what business trusts operate off of. Business trusts operate off of 9-8 numbers. Because they're private, they are foreign entities. They're not a creature of statute. But in order to maintain the integrity of the status that you're applying to it, you have to learn how not to taint your trust by engaging in some sort of conduct activity, drafting something into your indenture that would taint your trust and thus allow somebody to come in and construe it something other than a trust. Does everybody understand that point that I'm making right now?
Yeah.
Yes.
Was this a good introduction into what we're going to be learning over the course of these trust seminars? I'll tell you.
Yeah, of course.
Most definitely.
So what's the chapter to read for the successful management for the
I'm going to give y'all everything that I put in the Dropbox. I'm going to give y'all the book. I'm giving you the book page by page. Be in there tonight. All right, you will have it tonight. I'll give you page 1, page 2, page 3, page 4, page 5. It'll be just like that. You'll have all the pages. Read each individual page, and then we're going to go over it in our next webinar.
All right. So Yusuf, the beneficiaries, whatever, they can be like, since they be a person, so a person can basically be like another corporation.
Yes, so, beneficiaries can be beneficiaries. You can make another business You can make another trust as a beneficiary, but you got to watch out for that. That's what they call abusive trust tax evasion scheme. All right, and right here, you're going to see abusive domestic trust, abusive what? What do y'all see right there? Abusive what?
Foreign trust.
All right, so they hip to all the schemes. Business trust, the next step is the form of business trust. Again, very similar to a domestic scheme. Foreign trust one. And it's telling you what you're going to do. You have a trust, and then you're going to make another trust, the beneficiary of that trust, and then have it domiciled in a tax haven. All right? And they call it abusive. Everybody should read this. All right? This is something that you need. This is something that's required for you to know, actually.
But it can't be the only beneficiary, but it can't be a beneficiary.
Yes, it can be. Well, it can be the only beneficiary. Another business trust can be the only beneficiary of another business trust. They're two separate entities. They're not the same. They have two separate and distinct tax identification numbers. They're not the same entity. But what this is doing, why I'm showing you this, is because you're going to hear when you get into business trust. Because there are a lot of people out there trying to show people how to not pay taxes, period. And notice that the IRS doesn't call it an illegal trust. They call it abusive. It's not really illegal what you're doing. But,
they're abusing us. They're abusing us.
Well, I'm showing you this because you need to be aware that they know about the scheme, and you're going to be, when y'all started getting into this, you're going to come across somebody who's going to get into some trust structuring discussion and tell you how you can connect different trusts together and have the final trust being an offshore entity. Because when that trust makes a distribution, when it makes a distribution to a beneficiary, that beneficiary usually is a U.S. person, and that distribution is taxable. However, and you have to declare what the beneficiary is. If you don't declare who the beneficiary is, the IRS will automatically presume that the beneficiary is a U.S. person, and therefore a tax is owed on that income that's being distributed to that beneficiary. But what they are doing is they are creating foreign beneficiaries and putting them in tax havens, so therefore there's no tax on the distribution. Y'all understand what I'm saying?
Yeah. So like if you don't have no U.S. person, so basically if you if you're private, so then and you're a beneficiary, that makes you tax exempt, basically.
That's correct.
Awesome. So I got it. I got you. Say no more.
So can you be? But you can't be a beneficiary to more than one business trust at the same time, though. Is that correct?
Yes, you can.
Yeah, you can be beneficiary of many trusts you want to be. What you talking about?
But the key thing is do not be a U.S. citizen.
That's correct. And also, you need to understand the definition of income.
Right.
Income is a profit or a gain. Wages are not income. Right. Okay, you need to know the definition of income. You also need to understand, and we're going to get into a discussion about this, as a trustee, you can declare what is income and what is not. This is something that's very, I'm very careful about talking about that, but I will give you all that information because it's in the Internal Revenue Code.
So basically, in your trust indenture, you can say that the trustee would not get paid income; they would basically be confiscated for their wages. And
right. So, really, the purpose of a business trust, really, if you want me to tell you the truth, ultimately, at the end of the day, as a trustee, you want to avoid having any reporting requirements. That's the ultimate goal.
Yes.
And so as a trustee, you got to learn all the lawful ways that you can go about doing that.
I understand. I see like how you are actually being very careful, but I I'm seeing the picture, whatever, about
Wait a minute.
whatever.
Let me tell you, when we get into these books are going to touch on all of that stuff. It's going to if you thought today was interesting, it's going to get even more and more interesting progressively as we go. I wanted to do today because I wanted y'all, because this is how I was mentored. Okay. I was told that it was going to take me 6 months to learn this. And I thought I could do it faster. I was wrong. It's just my arrogancy. I thought 6 months, I'm going to fly through this. No, it does take about 6 months to become proficient at this. And if you don't have a mentor, you need to learn how to start reading case law. Case law, you see how much we learned for just reading that one case? And that case wasn't even real long. It was like a page and a half, But the thing is, you're going to learn so much from studying case law. It's ridiculous. That's what they do in law school. In law school, the lawyers primarily, they study cases.
Right.
And they learn procedure. Because you have to learn how the courts rule on certain matters. So you will know what to do and what not to do.
Mm-hmm. Hey, Yusuf, this is Tim from New York.
Hey, what's happening, bro? I can hear you.
I'm doing okay. Yusuf, so I actually created a trust this year, and I've actually opened up a banking account.
Right.
And I tried to open up another account with, I'll say the name of the bank, it's PNC Bank.
Right.
I have an account with them. So I gave them a certificate of trust.
Right.
Which says everything. And they're telling me that they want me to send the first 3 pages and all the signature pages. And I told them I'm not doing it because it's a private trust and it's a common law.
You got to go somewhere else. As a trustee, you just can't open it with them. They crazy. You're not giving them, all they need is the minutes from the trustees meeting is what really the only thing they need. Because you as a trust, we're going to get into that too. When you open up a bank account, one of the primary things that you have, every action that's taken in a trust has to be documented. It has to be agreed upon by the trustees and it has to be recorded in minutes. Okay, in those minutes, the trustees are going to decide what bank the trust is going to bank with, how they're going to open it up, who's going to be the signer on the account. All of that has to be documented in the minutes. And that should all be, that certificate of trust, as well as the minutes, should all be the only thing that they need.
Okay. All right.
Once again, that's a very good example of what I'm talking about. You as a trustee, you have to know what information to give them and what not to give them. Because if you give them too much information, the more information you give somebody, the more vulnerable you become.
Okay. So then the trustees.
Every bank has a different set of standards for opening up trust accounts. So if one bank is not playing the game, go to another one. Bank of America is a good place to go.
Okay, I'll do that tomorrow. But this is what I gave them. I gave them a certificate of trust. I gave them my EIN, the actual paper that you get from the IRS.
Right.
And I gave them a copy of my now, I don't know how you feel about this, but I actually created a Form 56 with the IRS.
Well, I don't know.
They had it stamped.
You can give them whatever you want, but usually it's going to come down to what they were requesting of you. You got to understand, they don't have to open up an account for you. So if they don't want to open up an account, you got to go somewhere else.
Okay. What a strange thing is, when I told them that I think that they might be in violation of the law because they had prevented my right to the contract, according to the Constitution. The next thing I know, I get a call from the senior executive customer service.
All right, what'd he say?
Well, it was a female, and she said, "Hey, they called right away, and they sent me an email saying, hey, we've been trying to call you, and you haven't responded, so you need to call us." So I called them today. I reached them today, and I explained to them what the deal was. And I said, look, I'm not giving you anything. You guys are going to have to write me a letter stating why you will not allow me to open up an account. And so she said, if you just fax me your certificate of trust, I will look at it. I will talk to my legal department, and I'll get back to you tomorrow.
Give them the certificate of trust, and you need to give them the minutes. I'm telling you. All right? Okay. That's what's going to really, the minutes are the lifeblood of the trust. All right?
Okay.
Give them the minutes of the trust, where the minutes in a meeting, y'all decided that y'all were going to go with PNC Bank, and then the trustees have all signed the minutes, and you give that to them. That's really all they need. That the certificate of trust, the minutes, that's it. They don't need nothing. Why do they need anything else? Anything else is business that don't have nothing to do with them. All they need to know is that the trust exists, you got a tax identification number, and the trustees who are trustees of the trust, they have all agreed that this is the bank they want to bank through. That's it. Anything else, they being nosy. They don't do that. They don't do that when you open a corporate. I got a business account. They do all that with my business. They didn't ask me. All they wanted was my tax ID number. You know what I'm saying? Name of the business and everything. They didn't go through all that with that. Why you need all that information? You don't need all that information.
I understand. I got you.
Hey, Yusuf, I was reading something in I think it was Arthur passing the buck, and I think that's what it was, but it was referring to getting an account open that is, I guess, easier to work with according to the state that you're living in, like having a state chartered bank to do business with.
Going to certain banks. Also, sometimes you may want to operate through a DBA. Have your business trust form a DBA and open an account that way. And we'll be discussing that too.
Okay. I'm wondering where the incentive or, the benefits to the trustees come from. Is that, when we're looking at that private prison, they're called...
They get paid. Trustees get paid. Trustees have a very good benefit. Not only did they get paid an administrative fee for administering the trust, they also are able to be trust certificate holders. It's a lot of benefits to being a trustee of a trust. A lot.
And that, I'm all guessing, is written into the indenture agreement.
We're going to go through an indenture agreement, trust me. But I'm going to make the indenture agreement last, because after we read and y'all learn all this stuff about trust, then when you read the indenture agreement, you're going to understand why all the stuff is in the agreement. So that's why we're going to do the indenture agreement last. Any other questions?
I was going to ask, as far as when you're preparing, for instance, when you're preparing to do business, okay, for instance, on tomorrow, here where I live, they are attempting to get more black businesses in this particular area of the city. So I'm actually one of the people who are going on there tomorrow for a seafood and soul food restaurant. But my question is, because I'm still kind of unsure as far as, because I'm wanting to go private, I don't have my trust set up yet, but when you're setting up the business, how should it be classified? Because if I'm wanting to eventually have my trust, in control of the business, because I haven't set up the trust as of yet, should I just go about it as, of course, a normal person would, or?
You can. You can start your business as a corporation, an LLC, and then later on, you can switch it over to a business trust. You said
start it as an LLC?
or however. I mean, I'm just, however, whatever good for you. You want an LLC, S corp, C corp? I don't know. What you're going to do. All I'm telling you is the assets of that corporation that can be conveyed over to a business trust later on, if you so desire.
Okay.
That's not a problem.
Okay.
But if you need to go on and get something done now, get it done now, and so you can start doing business, and later on you can convert everything into a business trust organization. All it is just like selling a car. Your car can be owned by a corporation, and then if you want to put it in a trust, you just do a bill of sale and sell it to the trust, and now your car is in a trust, and it's not in a corporation anymore. You got to understand that these entities are just like people. That's how you got to look at a corporation or a trust. You got to look at them as people, separate from yourself, able to do all the things that you can do. That's why you really have to ask the question, why would you really ever even put anything in your name? Even like this thing with personal credit. Why does anybody even use personal credit when business credit can do so much more? You can put an apartment in your business. You can put your home in a business. You can put everything in a business and have more tax advantages by doing such. But everybody wants to put everything in their own name. That is the fallacy. What's going on? The fallacy is everybody's been programmed to accept liability by thinking that ownership is the way. And it's not about ownership, it's about control.
Right. Okay. Cool.
Okay. That's it for tonight. Thursday, I'm going to put these documents in the Dropbox. We're going to be going over successful management. And we're going to do about the first 10 pages of.
Hi, this is Bezel Bay, and today you'll be enjoying WTDTA Radio, where we'll be exploring the world of accounting, current expected credit loss provisions, estate planning, and tax planning, just to name a few. Don't forget, in the evening session, we'll be definitely going into civics and syntactical trust. So remember, if you listen long enough, you will definitely learn something. Peace and love, family. Peace and love.